Humanos continua preocupante e os defensores de direitos humanos são frequentemente sujeitos às mais variadas formas de repressão, perseguição, rapto e violência psicológica e física. A Rede Moçambicana dos Defensores de Direitos Humanos trabalha para impedir o fechamento do espaço cívico e fortalecer a capacidade e resiliência dos defensores de direitos humanos no país. Estabelecida em 2020, a Rede Moçambicana dos Defensores de Direitos Humanos fornece assistência técnica para organizações locais
of the quality of democracy and the spaces that people are in right now, and it being completely shocking. The fact that it is possible to have legislation that is there to protect your rights and to technically protect you as a human being, but governments go around and abuse those legislations and they just disregard them completely. While ironically being signatories and sitting in bodies that state that they should be supporting and protecting their peoples. I think it came out yesterday that with democracy and human rights, the two are so symbiotic in nature and extremely interlinked that you cannot speak of the one without the other. It is only through a democratic system that human rights can truly be protected. But most importantly, I think what also came out is the fact that as civil society, we are continuously and have continuously and will continuously play a significant role in the consolidation of democracy and inevitably of human rights as well. We appreciate the speakers who came in again and gave us the contextualization of the experiences in the SADC region, but also hearing from the room the experiences that queer people have on our continent, that people with disabilities have on our continent. Lastly, the most important thing probably from this whole conversation was looking at the relationship that the Pan-African Parliament and CSOs have and where it's currently standing, looking at its successes, its failures, and places in which it can continue to work on itself. Most importantly, what was coming out of that engagement was truly whether or not people were aware of the Pan-African Parliament and its duties and roles and what it actually does to play. For the objectives of today, primarily the conversation rests on you. As Wunolo had said yesterday, some of the objectives that we have by the end of this meeting is to have a joint statement that we can put together and send to the plenary on the outcomes of this convening's discussions. But before we get into those objectives, Dr. Tembo is going to come up and come and talk to us about the different SADC mechanisms that we should be aware about and how they affect us as civil societies. And after that, after lunch specifically, we're going to have breakaway sessions. And in these breakaway sessions, we are hoping that at your tables, you can give us the input that you have with regards to the Pan-African Parliament and some issues and concerns that you would like to be recorded in the letter and the input and the statement that we're going to be giving to the Pan-African Parliament. We are already starting a little bit late, so my part is done at this point. I will see you all again during the breakaway sessions. I'd like to call on Dr. Srambashe Tembo to come up and do his presentation. Thank you.
Okay, good morning. My name is Simbarashe Tembo. So I'm just going to start by telling you one funny thing about my name. I know some of you understand Swahili, others Shona, others other different languages. And funny thing about my name is Simba means lion in Swahili, and Tembo means elephant. Then in Shona, Simba means power, Tembo means zebra. So I am a whole zoo here. So all the animals in my name. So yeah, so if you were just curious what it means. All right. So good morning once again, and today we are going to be doing a training, but before we do the actual training, I'm gonna do more like a presentation just to give you an overview of the SADC mechanisms, but I'm going to be focusing more on the notorious SADC tribunal. I'm sure we are all aware of it. We've been talking about it, and we just wanna go through what it has done, where it is now, and what holds for the future. All right, so before we start, because I prefer to engage with everybody, so just before we start, I'm going to just play a game. So we are going to play a game. I come from an academic background, unfortunately, so I kind of want to engage with everybody and make sure that everybody is involved in what we are doing. So can I have the other mic, the hand mic? I think it's on that table, yeah. All right, thank you. So I'm going to start here. We're just going to play a game. And I'm going to give you a pen, and you just pass it to the next person until it reaches to the end. But if one of you fails to abide by my rules, I'll kick them out. Okay, so that's how we're going to do it. All right, okay, you won't go out, but I'll kick you out, okay. Yeah, let's play the game. All right, so may you please pause. So all these three people should go out. Exactly, they didn't ask me what rules. What are the rules? What are you doing? What gets you kicked out? All right, so can we continue? So you guys are out, okay, but you can sit. We are past that. Yeah, continue playing. We're no longer concerned about the rules. Now you can continue. Or the main rule is just pass it to the next person. All right, so we are facing resistance there. Do you see that? Okay, so she's hesitating, she's resisting. Okay, so right. Okay, so in your view, by resisting, what is she doing? She's breaking the rules. Okay, so what she's doing basically aligns with legal scholars' question on what do you do to unjust laws, right? So if somebody tells you that there's a law, you don't know the law, whether the law is arbitrary, do you abide to that law? So she's refusing to abide to that law, right? And the law in this case is just pass the pen, but you don't know the rules. I might kick you out for failing to abide with a law that you don't know. So, okay, you can pass it next. We are done with you. Next. Yeah? No. We are done with the part of resistance now. Okay. Oh, okay. Let's start it afresh. Now you're starting. Pass the pen. You just passing the pen, because I said so. Okay, my instruction is pass the pen, isn't it? Why? So that she can. But if you break my rules, you go out. So pass the pen. Okay. You can, yeah, pass the pen. Okay, you can give it to someone else who wants it. But everyone must have the pen. Uh-huh. Uh-huh.
I was saying that I'm worried because I don't know what I'm passing and for what, and if my mate who will receive, does she need it, and does she want it, and also worried about the rules, because you said that we have to pass and we don't have to break the rules, but which rules? I will ask it, and if I don't have an answer, I will keep the pen with me.
Okay, so I don't know what to do with her. She doesn't want to go out, but she also doesn't want to pass the pen. What do we do? There are no rules. I know the rules. Right, so basically I was trying to illustrate dictatorship. We are here for human rights, isn't it? All right, so we faced resistance here. These are what you call, okay, I'm usually harsh. So someone with a better English that's kind to describe them. Can somebody describe this table? But
Yes, dear.
so that's actually a brilliant answer, right? You says they are patriotic. Someone mentioned the patriotic bill yesterday. Who was it? The speaker, was it you? Yes, the patriotic bill. So these are the people. How do you describe these people? You have gone around educating people about the patriotic bill. What are they saying? They just want, and exactly. So these are people that have a misconception of what patriotism means. For me, she's the one who's patriotic. And you are not. But you think you are patriotic. Why? Because she has the audacity to ask, why am I doing this? And how is this going to help me and everybody else? And yet, you are just receptive because it's coming from authority, and you think that's patriotism, of which that is not. That's docility. And here, this is a very, very docile table. Like, these people, extremely, because these people simply accepted the rules as they are. They don't even know the rules. And they think that they are abiding by rules, but I'm the only person who knows what those rules are. Right? That's dictatorship, isn't it? So this happens in our everyday lives and in communities. We have people that are arrested for committing crimes that don't exist. We heard yesterday about, was it Jacob Ngarivume, who was arrested and sentenced in Zimbabwe for committing a crime that has since been outlawed. Right? So these are the people that would actually happily go to jail for committing that offense. All right, so let's continue with our game. Please pass the pen. She's still not happy with that. She's still not going to do it. All right, so these are the people that we want in society, right? People who say enough is enough. We can't continue playing a game because it doesn't have rules. Why should we play? Right, so I would see this person as an activist. So in this 1, 2, 3 tables, you are all gathered here as activists, but you are not. Right? Because you accepted. She kind of resisted, but then She accepted. Stood her ground. Right, so this is the type of person that would actually say, if you're going to put me in prison, put me, I'm going to stand by my principle. Right, she stands by what she believes in. She kind of, yes, she knows that this is wrong, but eventually she was, okay, let me just give it in. Don't you see those people in our communities every day? We have activists, human rights lawyers, politicians, who when they speak in front of people, you think that, oh, okay, so this person is really principled. But the following day, if they are pushed to the limit, they'll give in. That's exactly what she did. So she is the direct opposite of her, right? And here I won't talk about them. All right. But I'm the only person who knows what that law is, isn't it? So I put her into prison. Who is she going to respond to? Who is she going to report me to? She has resisted, I throw her into jail. Who's she going to report me to? To the state. But I am the law. I am the state. So you come and report that you have been violated by me, and you are reporting to me. That is the nature of governance, isn't it? So our state structure is built in such a way that the state violates you. Oh no, the state gives you rights. The state takes away those rights. It violates them and asks you to report. You need it? Okay. All right, and ask you to report any violations of those rights to me. Right? How do you think I would respond to your complaints? Do you think I'm going to put myself in jail? Do you think I'm going to punish myself? Okay, so that's unfortunately the nature of society, and that's what we have to deal with every day. I'm not here to challenge state structure, but I'm just here to enlighten you on some of the challenges that people face every day and the effects of the current state structure that we have. Yes, we do have what are called human rights commissions, independent institutions, but are those institutions really independent? Who appoints members of those institutions? When they do investigations, who do they finally put their reports to? To the very same people who has been perpetrating those violations. So that's basically what is happening in SADC. That is happening in SADC because we do not have a supranational judicial body that, if you have exhausted all remedies internally, where do you go? You've been violated, you've gone to the courts, you are not happy with the courts. What's next? Where do you go? So may somebody tell me, if you were to go to the constitutional court of your country today and you are not satisfied with the decision that has been passed against you, where do you appeal? You put your tail between your legs and go back home, isn't it? But that wasn't the case just less than 2 decades ago. I mean, maybe less than 15 years ago when we had the SADC tribunal. So the SADC tribunal acted as a supranational judicial body that if you have exhausted all internal remedies or domestic remedies, you'd then go to the SADC tribunal and be heard. Right, for those of you who understand the law, was this a good or a bad thing? I said it's interactive, so feel free to speak. I'm not here to give a speech. Anyone? Yeah? Mike?
So I think it was a good thing because at least you are getting into a space where there is some sort of neutrality.
Anyone with a different idea? Okay, so at least you'd get some, okay, yes. Sorry, I can't see the other person in the corner there. Yes.
Bom dia. Nós fazemos parte das comissões técnicas especializadas da CONSADEC. Ao meu ver, nós precisamos da sociedade civil e nós temos sempre reuniões com o governo, mas sentimos que há situações em que o governo reúne-se eles à parte e também tem sessões que reúnem-se portanto, com a sociedade civil, né? Não sentimos ainda integrados como sociedade civil dentro da CONSADEC e a SADC por conta dessa situação em que sentimos que a SADC ainda é política, ainda tem situações que discutem entre os presidentes, entre os ministros e as coisas ficam por aí. Portanto, é aquele nome que se dá, ele é juiz e réu da mesma causa. E então fica muito difícil. Nós estamos há 21 anos quase da CONSADEC, da SADC, da SADC, sim, e que os resultados que nós desenhamos nesses 16 países da coisa, ainda não tem resultados. Portanto, estamos a dizer que aquilo que se discute na CONSADEC, o destinatário final não sente este processo, mas apenas os políticos é que sentem aquilo que está a acontecer na SADC.
All right, so I'm glad that point touched on a very important issue of the current SADC structure. So the current SADC structure only has the political organ. It doesn't have the judicial organ, right? So at the moment, if you have any grievance and you want to take it to SADC, you are simply taking it back to the very same people that you are complaining against. And these are the political organs. Right, so we do not have a complaints mechanism as the SADC organization stands at the moment. Right, so that's basically the point that was being made there, and it's actually very true. And it's quite unfortunate that we have reached here simply because our leaders do not want to be accountable to their own citizens. And someone described the SADC as a brotherhood. Is that true? Okay, I'm not going to be talking about whether brotherhood or sisterhood. Okay, but yes, so they are indeed a brotherhood, and you complain against Mugabe or now Mnangagwa. That means you have also complained against Ramaphosa, you have also complained against Masisi, you have also complained against Hachilema and so on. Why? Because they are scared that whatever precedents they set will also be used against them in future. So that is the current challenge with seeking judicial resolutions through political means, because they always put politics ahead of any other interest. All right. So, yeah.
Good morning once again. Well, I have idea that might be what we are supposed to have, but we are don't having now. One, I'm not a lawyer or things like that. I'm just an activist. Actually, I'm monitoring and evaluation officer. But I do work with organizations that do this work all the time, so that's why I'm here. But I think that the what it was supposed to be is when we are facing things like what we threw 1-2 months ago in March with Azagaya, with our merch and things like that, when we saw that we was being violated by the state, we were supposed to call the SADC, call the African Union. We are supposed to have their support. They have to send not just statement, as our mate was saying yesterday, but more than it. We were supposed to receive from the SADC, United Nations, and all these things, sanctions, or how it's supposed to say, maybe the translator can help me, represálias por parte destes membros que nós fazemos parte, nós como moçambicanos fazemos parte, we made part of SADC, African Union, United Nations, and all this. But we didn't show the support of this. And also, I was hearing yesterday that Zimbabwe, South Africa, and all the countries was facing things like we are facing, but they don't have our support also. So I hopefully that from today we leave this room with a strong network that will pressure all the communities to be not just a name union, but to be a union effectively. We saw United Nations calling our president, and he was there and he was lying, but after that nothing happened. And more than people that lost the eye and things like that, I saw people dead, but until today we didn't hear anything from that. So I have idea that what is supposed to be, but it's not happening. Our union is not being effective. Our union is just working to put us in the rooms, put us going to other countries, doing exchange, networks, and things like that. But what we are supposed to effectively do, we are not doing yet. And I hopefully that we end here, we end today with guidance, and more than guidance, we have a to-do list that we have actually to do. Thank you.
All right, that was brilliant. So basically, you have exposed a number of weaknesses that, you know, civil society has, right? We come here, we sit together, we drink coffee, we go back to our countries, we meet again next year, we do the same thing, we write some statements, we publish them. But where is the real power of what you have actually agreed on? Where does it lie? It lies in the unity amongst those organizations and how much power you can pull together and come up with something solid. But the main challenge is that civil society usually wants to avoid playing politics, and yet they are very involved in politics, right? So sometimes what you need is actually political capital in order to achieve your goals. And how do we amass that political capital? Maybe that's a question that needs to be answered at the end. Should civil society align itself with political lobbyists in order to achieve its agenda? Should civil society remain neutral? Should civil society work with the judiciary instead of the other executive organs of maybe SADC or even in individual states? Right, so those are questions that actually arise from what you have just said. Thank you for that. All right, does anyone have any contributions to what has just been said? So yeah.
So mine sits as a question around exhaustion of local remedies. And I ask this as someone who's working with women or who are in mining impacted communities, and some of these communities are militarized. And some women experience rape at the hands of the police or at the hands of the military. And then when they go and report the cases, dockets go missing, or the person who has raped them is removed from the camp, and so it becomes very difficult to even use the local remedies because there are structures in place that make sure that you're unable to even have access to the local remedies. So what then becomes the recourse in such instances?
All right. So those are the challenges that we face. The same perpetrators have their own structures that basically block every remedy that you may want to use. And you are left powerless with no recourse. And the SADC tribunal is not there. Does anyone here think that maybe if the SADC tribunal had been given maybe a chance for a few more years, it would have probably provided the recourse that we actually saw in for? Or it would have probably become another captured body? I mean, all our courts are captured, isn't it? You go to Mozambique, you hear the same complaints. The judiciary is not independent. You go to Zimbabwe, the judiciary is not independent. You go to South Africa, they are crying now that the judiciary is making some really funny decisions. You go to Namibia, maybe Namibia is a little bit different, and Botswana. So do you guys think that the SADC tribunal would have been different and not captured by the SADC summit, which basically appoints the judges? Yeah?
No, thanks. My take is that I think since from yesterday's discussions,
Yes.
I was sitting here thinking about after the presenters, I discovered that we are seemingly all having the same problems as member states in the SADC. And I was asking myself, what makes us not to find a solution, because the problems are common? And just before we get to the solution, my question was, if we look at what is happening, what could be the root cause? Because I think that is where we need to start. What is the root cause? What makes our leaders to all behave like they are fathered by the same father and mother? we must then go beyond just looking at the individuals who are occupying seats at that particular time and look at whose agenda are they pushing. Do we really have a strong feeling that they are pushing a personal agenda? And the question would be, how does it happen that everybody who's elected, almost all our SADC states will be going for elections this year, different people coming in, but pursue the same mandate. And their behavior becomes the same. It doesn't change in any way. Then we get to all say that our courts or our judicial systems, our legislative systems are captured. The question is, captured by who? How does that person manage to capture all the states? We must then go to that root cause, I think. Because from where we are sitting now, we can have brilliant ideas in terms of what can be done. But we must know who is controlling the whole system. So that's what is boggling my mind at the moment, to say, how do we get out of this situation? Let us go just beyond looking at these things in narrow eyes to say, we have a problem in Swaziland, we have a problem in Mozambique, we have a problem in Namibia and all other states. What makes us to have similar problems, if not the same problems? Then the SADC tribunal, if these courts and judiciary systems are captured from individual states, then it's obvious what would happen at the SADC tribunal. Because it's the same people, the judges will be coming from the same countries. But then, how do we expect them to have changed now when we're at the SADC tribunal? That's what is in my mind. Thank you.
All right, so that's a brilliant point. I was just thinking, that's actually a very, okay, so I didn't know how to put this. So the SADC summit is made up of heads of states and governments, right? The SADC summit is the one that appoints these judges, right? And the SADC summit usually, the heads of states and governments are the ones that are complained against by people who take matters to international courts. What makes us think that they will also not come together and also capture the same judicial institution that they set up? But we have examples. That's the brilliant thing about this, that so far we can use the ECOWAS court and the East African court as examples. They've fared so well. They do have their own weaknesses, but we haven't seen that happening. It is not a it is not an impossibility, but I think there's also hope in that if the SADC tribunal is perhaps reinstated, we can also have something similar to the East African Court and the ECOWAS, perhaps. We don't know what the future holds. No one can really predict, but maybe if we have the same structures, the same instruments that are similar to the ones that have been used to maintain the institutional integrity of the ECOWAS and the East African Court of Justice, maybe we can talk of a stronger tribunal in future. All right, so let me just then go to giving an overview of why we need sub-regional judicial mechanisms in the first place. So with the SADC tribunal, it was established to interpret the founding treaties of the SADC organization, and for dispute resolution amongst member states, individuals against the states, as well as employees of the SADC and employees of NGOs against states, and so on. Right. So it had a very wide jurisdiction. But the primary role that the SADC tribunal was established for was to interpret the treaties of the SADC. Now, this was not done in order to ensure that there is protection against human rights violations. Human rights were probably not on the agenda when these leaders met to establish the SADC tribunal. Human rights were probably not on the agenda. What was on the agenda was to deepen cooperation in the region, to ensure that there is economic integration and political solidarity. Because they don't mention it, but that is their idea. Whenever these leaders come to say they want to resolve a problem, they are not resolving any problem. They are simply meeting in solidarity with each other. That is why the SADC summit has never made a statement against any leader or against any member state, because it's a solidarity club. But it's unfortunate that we place so much trust in that solidarity club to establish a tribunal to handle complaints against itself. So, regional and sub-regional mechanisms are not unique to Africa. We have in America, we have the Inter-American Courts. In Europe, we have the European Courts. And both of these courts have human rights jurisdiction, and they were established with human rights jurisdiction. And where they were not established with human rights jurisdiction, they actually acquired that jurisdiction through interpretation of their treaties. Something that the SADC tribunal rightfully did in 2007 in the case of Michael Kemper versus Zimbabwe. But it is the very same case that sought to expand the jurisdiction of the SADC tribunal to include human rights that led it to its demise. At first it was suspended. Now there's a question of whether the SADC tribunal was disbanded or it was suspended. I don't know. What do you guys think? Is the SADC tribunal suspended or disbanded? Because there is, you know, even if you want to seek legal recourse against the SADC summit, you don't even know whether you're going to be saying it's currently suspended or it's currently disbanded. All right, someone said it's disbanded. In what manner? If you are to say that the SADC tribunal is currently disbanded, in what manner was it disbanded? Was there any protocol that was maybe adopted to disband the tribunal? Was it, I mean, it was established through legal means. It also had to be disbanded through legal means, isn't it? Then those that say it was suspended, the argument is that at first the judges' tenures were not renewed, and that's it. There are no judges. The tribunal is there. It's a building. But there are no judges in the tribunal. The files that were, the cases that were filed between 2007 to 2009 are there in the tribunal. They just don't have any adjudicator. So what are the hopes? What hopes do we have for the future? Do we reinstate the tribunal, or do we set up a new court? If it's disbanded, then you need a new court. If it's suspended, you reinstate it. We have legal minds here. Let's perhaps try and figure this out. Because at the end of the day, we need to make a call for either reinstatement or establishment of a totally new court. So what do the legal minds we have here think about this? Which way do we take? Yeah?
Yeah, unfortunately, I'm not a legal mind.
Yes.
But I want to say that from my understanding, it was disbanded. And we might then also have to look at the reasons why it was disbanded.
Yes.
Because they would also have an effect in our call, either for a reinstatement or maybe establishment of a new setup. Because we must also try and look at what were the hiccups or the shortcomings of this particular court.
Yes.
So my understanding is just that it was disbanded. So we may have to collectively look at what could have been the reasons and then make then our own recommendations in terms of what do we want. Because we must also look at how best can it be utilized or how far can it go in terms of assisting us in what we are calling for.
Okay.
Thank you.
All right, so why the tribunal was disbanded? The tribunal has a very interesting history. The tribunal was conceptualized in 1992 in the SADC Treaty. The protocol was only adopted in 2000, and it received its first case in 2005. That's when the tribunal opened its doors. Can somebody explain those gaps? '92 to 2000, then 2005. I mean, the judges were only appointed in 2005. Can somebody explain those gaps? My academic mind would tell me that there was never any political will in the first place to have a tribunal. They knew that there is an idea that would probably instill investor confidence in the SADC region, that if investors come here, they will know that their legal disputes will have some supranational judicial recourse. So to attract investors, they came up with the idea that in the treaty, let's say we are also going to set up a judicial body that will be responsible for dispute resolution. But then it took them about 8 years to adopt a protocol to establish that judicial body that they wanted to have. We understand that there are arguments about South Africa going through its transition, and maybe that's why there was those delays, but I do not agree with those. There was never political will in the first place. Then, in 2005, the judges were appointed. That's another 5-year gap from 2000. Another demonstration of lack of political will. So for me, the SADC tribunal was indeed established, but those who established it never really wanted it, right from the beginning. Even if you look at the manner in which the tribunal was established, there are legal arguments that were put forward by Zimbabwe. Brilliant arguments that the tribunal is itself illegal because the protocol was never adopted. Do you guys know that argument? So an argument was put forward that the tribunal itself is illegal. It's an illegal structure. It was adopted, but it was, I mean, the protocol itself was never, the protocol was enacted, but it was never adopted. And then in 2005, they appointed judges, and the tribunal opened its doors. So for me, I think that the tribunal was doomed to fail right from the beginning. Then it received the case of Campbell versus Zimbabwe, just by way of background. Zimbabwe was doing its fast-track land reform program, and Mike Campbell was a former white commercial farmer who lost his properties to the government through compulsory acquisition under the land reform. Then Mike Campbell took the case to SADC. At first, he applied for an interdict against any interference with his property, and that interdict was granted. That is the first Mike Campbell case. Then that was joined by 77 other applicants who joined that application for interdicts, and they were granted. Now, this is happening at a time when the general feeling in South Africa is that we need land. Julius Malema, still in the ANC Youth League, starts talking about redistribution of land. But having seen the chaos in Zimbabwe, SADC leaders were very cautious that if we let this set any precedents against issues of land acquisition, then we are never going to have our own land redistributions in our own countries. That is why there was general consensus on the issue of disbanding the SADC tribunal. Only notable opposition coming from Botswana. The rest were in agreement with suspension or disbanding of the tribunal. In 2009, should be 2009, a judgment was passed in the second case of Campbell. This judgment was rich with legal reasoning. That is the judgment that basically expanded the jurisdiction of the SADC tribunal to include human rights. Because the interpretation was that if you are going to be talking about democracy and good governance and dignity, those are intrinsically linked to human rights. So purposive interpretation of the SADC Treaty and the protocol basically gave the SADC tribunal a human rights jurisdiction. Then these old men, none of them is less than 60, so realized that, oh no, this is going the other way. Why not put a stop to it? Robert Mugabe was the leader of the fray at the time, and he led a very vigorous campaign against the SADC tribunal. At every opportunity that Robert Mugabe got a microphone, he spoke against the tribunal and its judgments against land reform. So basically that rallied other leaders in the SADC to actually agree that, okay, the SADC tribunal should not, should be disbanded. So why did Campbell take the case to the tribunal? Zimbabwe has some really educated judges who can surely read the constitution and understand it. Why seek recourse elsewhere? The reason was Zimbabwe had made a constitutional amendment that ousted the jurisdiction of any court. Listen to this. It ousted the jurisdiction of any court to hear any matter pertaining to land redistribution. When we started, I started by playing a game, and I said, this game has rules, but I'm the only person who knows those rules. How different am I to Zimbabwe? Saying that if you're aggrieved, go and cry at home, don't go to any court for any legal recourse. So because the SADC tribunal was there, after having failed to get any legal recourse at home, Campbell approached the SADC tribunal and he got a favorable judgment. Now, the aftermath of Campbell is very interesting, because what then happened is there were many other cases that followed. So the first case was the case in which it's called Gramara Limited versus Zimbabwe, in which those people that had been given that interdict, the 77 people, now sought to register that judgment in Zimbabwe. Remember, the violations have taken place where? In Zimbabwe. The SADC tribunal, which sits somewhere there, has made a decision against Zimbabwe. And the SADC tribunal does not have police officers. It doesn't have any jurisdiction over Zimbabwean territory. Now, the same judgment that is being opposed by the government is now to be registered in the country run by that same government and enforced by the same government, because there were interdicts that were there. What do you guys think happened? Or what happened? So obviously, it was obvious. I mean, the judiciary in Zimbabwe refused to enforce that judgment, to register that judgment. Because in law, if you have a judgment that has been passed for you, and this judgment includes any enforcement or judicial enforcement, you have to register to the court for enforcement. Now, I'm just going to move to, I just want to read something that was said. So in the case of Gramara, this is what the judge in that case said. He said, this constitution is the supreme law of Zimbabwe. If any other law is inconsistent with this constitution, that other law shall, to the extent of the inconsistency, be void. The obvious implications of the supremacy of the constitution are twofold. First, to the extent that the common law is invoked to enforce a foreign judgment. Now, funny, you know, the SADC tribunal was an organization based on consensus, isn't it? By all the state parties to it. Now they're calling a judgment of the tribunal a foreign judgment. Now the SADC tribunal judgment is now being called a foreign judgment, and they say the common law must be construed and applied so as to conform with the Constitution, and any feature of the judgment that conflicts with the Constitution cannot, as a matter of public policy, be recognized or enforced in Zimbabwe. I teach law. If you ever send your kids to me to teach law and they come back telling you this, please kill me. I will have failed. Surely this is one of the most ridiculous judgments I've ever read. In my view, this judge should have just reserved the judgment indefinitely and dismissed the case. I think it would have saved the country of so much embarrassment. Then, the judge goes on to say, the notion of public policy cannot be deployed and insinuated under cover of the common law to circumvent or subvert the fundamental law of the land. Secondly, I consider it to be patently contrary to the public policy of any country, including Zimbabwe, to require its government to act in a manner that is manifestly incompatible with what is constitutionally ordained. Right. What is constitutionally ordained that was being referred to here? Does anyone have any idea what they were referring to in this case? It's a constitutional amendment that ousted the jurisdiction of courts in matters involving land. Now they are saying that's constitutional. Instead of testing the constitutionality of the provision that is being challenged, the court sought to question the use of the common law that was relied on by the lawyers in this case to have the judgment enforced in Zimbabwe. So basically, these are the kind of judges that we have entrusted to resolve our disputes, to attend to our grievances, and yet they have the audacity to tell you that a judgment of the SADC tribunal is a foreign judgment. To me, a foreign judgment is a judgment that is passed in a fellow sovereign country to be enforced in another sovereign country. That is a foreign judgment, not a judgment that has been passed by a supranational judicial body that was built as a result of consent and consensus by the parties to it. Yeah.
Yeah, thank you. I think this takes us to what I had earlier raised.
Indeed.
To say that, you see, the issue of the political will is so important in terms of how these organs are going to operate. These violations, they start from the individual countries. And then there is this abuse of the sovereignty of states. That is why then an organ created by these member states will then be referred to as a foreign one. Because the other thing is that after having passed this judgment, and then Zimbabwe refused to abide now by the ruling, what's the next step? Because we should also talk to that. What would be the next step? And will that then next step, if it affirms the same decision, would it then be respected by those countries to whom the judgment is passed? But generally, when you look at then the SADC heads of state, they behave the same way, and they all violate human rights. Then the question is, you raised the issue of, do we call for a reinstatement of this organ, or we look at something else? And from where I see it, this organ will never achieve its intended objectives. Yes, I agree with it said it's the ECOWAS organ that is there for the judiciary. It might have done a good job, and then it will also talk to the political will, because how will those judgments be enforced in those countries? That's what is more important now than just to have the organ which will pass judgments that cannot be respected by member states. So I think there is something that is lacking in terms of how do we make sure that everybody abides by the decision that has been taken by the court? Are we all as member states willing to accept the judgments and enforce them in our own countries? The challenge is that they are all violating their rights. And generally, the cases that will be taken to the SADC tribunal are going to be cases of human rights violation. Why violate them in your own country when you will provide a forum whereby the people are going to take their cases to, win them, and then will be forced to then comply? Then they will block everything that might take them to that particular end. So that is what I foresee here, not unless we look at other strategies in terms of this. I mean, the recent one is that of Putin, the ICC. What's happening now? Because we must look at how these organs are functioning, even internationally, so that we can borrow or adopt certain things that can then be enforceable within our own boundaries. Because, like I said, our problems are the same. Yes. Thank you.
So basically this takes us, oh yes.
Yeah, I just want us to note that the way the leaders behave, it is in the manner they never respect the citizenry or the voters, if you like. Because I can imagine in the West, in America, in England, where the people's vote matters, there is no way those governments in the European Parliament can undermine the voters, because they know the consequences of that. So I think the body politic in our region, in our Africa, is in such a way that the ruling elites, they know there are no consequences to their actions. If we don't, as citizens, coalesce and fix the politics by way we vote and demand things, the situation will persist to the foreseeable future. Thank you.
All right, thank you. Any other contributions? Yeah.
Maybe I also want to share something. Unfortunately, I come from the workers' side, which every year we go to ILO, which is a body whereby you find that workers, when they have issues in their own countries, they report them to that structure. And once a decision has been taken, then the ILO sends a delegation to that particular country, or they force that government to respond to the cases that have been reported about them. And if they are found to have been guilty, then there are consequences. They are put in the special paragraph, and they get sanctions and all that. It has been effective for workers, because every government does not want to violate workers' rights, because they know that when they get to ILO, then there are consequences. Whilst looking then at that, over the years there's been now a trend of then business coming in to influence how the decisions can now be made. That is why now it is even much difficult to take countries to the special paragraph, not unless it's severe violation of human rights. And you have now to prove beyond reasonable doubt that this is too much for the people in that particular country. Because capital has now got into the system to make sure that it's less of cases that are won in the ILO. So it's another battle. So even in this angle in which we are in now, we must understand that there are interests of other people on the other side. Because capital, in its nature, uses these leaders who are in the leadership position to make sure that they come into the countries to make sure that things go their way. So that is why then you'll find there'll be no political will in terms of these tribunals that we are putting up in every corner. But they will always have a way out of it. So that is where I want us to at least deliberate on those and have a full understanding of who is controlling the whole system. Thank you.
So I just want to respond to that directly. So for the record, this is my own personal opinion. It's not backed by any research, what I'm going to say now. Have you ever observed that the nations that are pro-human rights are Western liberal countries? Then the countries that do not really care about human rights are China, Russia, and the former Soviet bloc. Now we have countries like Belarus coming to invest in mines in here. Why do they find these countries to be fertile ground for investment? You mentioned capital. So who's controlling? Back in the days, our countries adopted constitutions, which are liberal constitutions, because they wanted donor aid. And that donor aid was Western donor aid. It was coming from the Bretton Woods institutions and the USA. Right now, they don't care about the West. They are looking east. And the East doesn't care about human rights. Human rights are used as a pretext for investment by Western nations. The East doesn't care. The East actually thrives in countries where there are human rights violations because they themselves don't care about human rights in their own countries. Yeah. Okay, my disclaimer, you remember it. Yes.
I remember your disclaimer, but I
Yes.
also want to say that I think our colonial masters don't care about
Us anymore.
us as well. No, they've never cared about us. It
Okay.
has always been about, when you look at our colonial histories, and when you look at the ways in which even some companies that we find in most of our countries are also coming from Europe, from this so-called liberal, and they're also looting.
Okay.
So when we look at the East and the West, and they all have the same mandate. They are about developing their own nations using capital or investments from Africa. So that's my take.
Okay.
Others hide behind being human rights, being liberal, but when you look at it in essence, they may protect the interests of their own citizens, but they don't care about African interests. So they'll push certain agendas because those agendas are of interest to them. So I think we also need to have like okay, this is my take. I think we need to have to look at issues around human rights, and I think we also need to start thinking about what do human rights mean for us as African people, and what does it mean to be advancing our own human rights agendas that suit us. And that is also about being critical about the role that even these European nations play in propagating human rights violations in our own countries.
Okay. All right, so maybe it's twofold. Maybe there are both ways to it. Then you mentioned the issue of enforcement. Yes, indeed, we do not have enforcement mechanisms when it comes to judicial decisions of supranational bodies. And remember, international law is based on the issue of consent. The hope is always that if a judgment is passed, any country that is a party to any instrument of that judicial body will then enforce it. But surely that hasn't been happening. So do you think perhaps that if the tribunal is to either be reinstated or to, if there's going to be a new tribunal altogether, maybe that tribunal should also include some enforcement mechanisms, maybe punitive measures, sanctions, such as sanctions, and so on? Maybe perhaps that is something that is to be considered, yes.
you've got all these different mechanisms that are available, complaints mechanisms up to the UN level, but the lack of an enforcement clause or provisions is what is the biggest hurdle. That's why you find that these recommendations or resolutions are called that, recommendations. And when somebody gives you a recommendation, it's either you take it or you don't. So when we reconfigure or restructure our SADC tribunal, I think that's the first thing that we have to ensure is in there. You know, the ECOWAS model is a good one. Perhaps we can also strengthen it. But then the biggest problem is that if we give our governments the option of whether to accede to the SADC tribunal at all, we see it when you're talking of the African Court. Very few countries have deposited that declaration to the African Court, and some have even withdrawn the one that they had filed. So there has to be some form of provision that says, if you are a member state, you are obligated not only to accede to the authority of the SADC tribunal, but also then to also enact enforcement clauses that will ensure. And not just the enforcement clauses, then the punitive measures that will be faced if you do not conform. Because we'll have an enforcement clause that says you are bound, but then if you don't do it, then what? I think that's where we've been lacking, and I think perhaps if we can be proactive around it, because we are talking about bringing the SADC tribunal back, so I think that's the task for us.
Our main stumbling block is this whole dualist, monist countries divide. I believe that if maybe all the countries were to be forced to say, once you have acceded to a particular treaty, you have an obligation to go then and enact a legislation that says this particular law is law in the country and is enforceable in this country through domestic mechanisms. I think that could work. But the problem is always that they will tell you that once ratified, then it automatically becomes law in our country. But they know that they're never going to enforce it because there is no enforcement mechanism. So perhaps maybe something to consider for countries that ratify a particular law to then enact a subsidiary legislation domestically that incorporates or domesticates that particular law. All right, so I just want to refer to something that's a statement that was made by the Minister of Justice of Zimbabwe when it came to the issue of enforcement, because that's the main issue, enforcement. How do we enforce these judgments when you are faced with people who are so arrogant that they say this is directed to the SADC tribunal, right? And this is a minister of justice, someone who studied law and perhaps calls themselves a human rights lawyer. They say, we hereby advise that henceforth we will not appear before the tribunal, and neither will we respond to any action or suit that may be instituted or be pending against the Republic of Zimbabwe before the tribunal. For the same reasons, any decisions that the tribunal may have made or may make in the future against the Republic of Zimbabwe are null and void. This was the end of the tribunal. This statement was the master stroke. Now you have one country saying this after you had agreed to establish a tribunal. Now because decisions are made against you, you start backtracking, and so that's how the tribunal basically got suspended and disbanded, and that's where we are now. Then following that, there are a number of cases that then followed. the main case is that of FIC. So FIC's judgment is very interesting in the sense that FIC was one of the applicants and one of the 77 that joined the Campbell cases. And FIC was actually Campbell's son-in-law. So he even continues to fight in the Campbell cases up to now because those judgments still need to be enforced. So what FIC did was he made an application to the SADC tribunal at first, and that application was granted, but then there was still no way of enforcing that judgment in Zimbabwe. So what FIC then did was he went to South Africa and applied in the South African High Court for an order to attach Zimbabwean assets in South Africa to enforce that judgment. Now the South African, so this case went all the way to the Constitutional Court. And the interesting aspect of this is, I love the South African Constitutional Court. It's very pragmatic. What they did is, they didn't look into the politics of the case. They said, there is a judgment that says A pay B. That's all they looked at. The judgment said, you owe so much, so you have to pay it. So the South African Constitutional Court granted the application for FIC to attach Zimbabwean property in Cape Town. Now, of course, that property wasn't enough to satisfy the judgment, but I think there was a moral victory in that, okay, yes, Zimbabwe has refused to enforce these judgments, but you can enforce them elsewhere. That's basically what happened. So, in another case that then came in 2010, that's called the Commercial Farmers Union versus Minister of Lands in Zimbabwe. The High Court in Zimbabwe held that the SADC tribunal has not been domesticated by municipal law, therefore enjoys no legal status. Now you see the excuse that they used. Exactly what I was saying a few minutes ago, that if you use the dualist and monist approach, then you are doomed. Right? If you enact a legal instrument, an international legal instrument, you have to make it mandatory that that country enacts a legislation that incorporates that treaty into their domestic system, so that they do not come with an excuse that we did not domesticate this. So they said they did not domesticate, the SADC tribunal has not been domesticated in Zimbabwe, therefore enjoys no legal status. But if you look at the monist approach says international law is law in your country, isn't it? If you ratify an international instrument, then it automatically becomes law. It becomes part of the domestic law. But then Zimbabwe disputed that, and they said, so this is the judge saying, I believe the same obtains in all SADC states. Now look at how, now they're pushing an agenda, right? I believe the same obtains in all SADC states. That is, there is no right of appeal from the South African Constitutional Court, the Zambian Supreme Court, and now the Constitutional Court, and the Supreme Courts of other SADC countries to the tribunal. So the tribunal was never set up as an appeal court. Everyone knows that, every legal mind knows that the tribunal was not an appeal court. It could be used as a court of first instance where domestic remedies have been exhausted. It wasn't an appeal. It was simple. You could make a fresh application with new evidence in the tribunal. You did not have to go with your file from the Constitutional Court. No, you could actually make an application in the tribunal. But this judge has a different view. He sees the tribunal as an appeal court, of which it was not. So these are some of the weaknesses, inherent weaknesses that were there in the tribunal, that it wasn't exactly expressed whether was it going to work as an appeal court, was it going to just be a court of first instance, how was it really going to operate? So if the tribunal is to be reinstated, these are the things that need to be taken into account, things that need to be thought through. I mean, you can never plug in all the loopholes, but yeah.
Desculpa interromper. Eu penso que nós devíamos fazer alguma reflexão aquilo que acontece nos nossos países. Por que que foi formada a SADC? Nós temos que começar com a SADC. A SADC começou para a libertação dos povos da África Austral, né? E era um movimento político que o objetivo único era a libertação da África do Sul, do apartheid. Estamos a falar do Zimbábue, de Ian Smith, estamos a falar de Namíbia. Portanto, esses países que tinham que se libertar. A partir dali, aqueles que pensaram nesse projeto já não estão. E o PIN ficou com eles. Então, nós tentamos olhar para nós e dar continuidade, né? E essas etapas que nós não conseguimos ultrapassar, nós estamos a falar, por exemplo, dos nossos protocolos que são assinados ao nível da SADC, ao nível da SADC, que se transformou-se passou-se da SADC para a SADC. Os protocolos que são assinados pela SADC refletem nos nossos países, povos, cada um de nós está aqui, que é representado pelo ataque à África do Sul, que eu saiba, Zimbábue, Eswatini, Moçambique. Se perguntarmos cada um de nós, esses protocolos que são assinados na SADC, na SADC, refletem-se naquele camponês, aquela pessoa, a última pessoa que está ali, aquele camponês que se encontra portanto, a fazer a sua agricultura, a fazer a sua pesca, reflete-se isso. Portanto, nós estamos a alterar, nós estamos a querer criar um tribunal, temos a querer evoluir para um tribunal, enquanto aqueles protocolos básicos, livre circulação de pessoas e bens, portanto, estamos a falar de zonas transfronteiriças. Nós temos problemas entre povos aqui, o que acontece entre Moçambique e África do Sul, o que acontece entre Moçambique e Zimbábue, o que acontece entre Moçambique e Malawi. Portanto, temos problemas aqui internos, portanto, aquilo que está a chamar de domésticos, né? Problemas que não são resolvidos e queremos resolver um problema dos outros. Portanto, e ainda continua a ser politizada. A SADC continua a ser politizada e é preciso começarmos a fazer esse tipo de reflexão. Portanto, eu, como defesa do consumidor, nós fizemos no ano passado uma reflexão a nível de Moçambique. Tentamos fazer uma conferência a nível dos 16 países para saber a integração regional, o consumidor e a integração regional. O que significa esses protocolos? Nós só ouvimos falar desses protocolos, mas aquilo nós não sabemos o que é, ok? Então nós saltamos etapas, continuamos a saltar etapas e no final do dia vamos só nos acusarmos e não vamos conseguir ir para frente. Vamos dizer que não, esse é o problema dos políticos, esse é o problema portanto, da oposição, é um problema da sociedade civil. Agora aqui em Moçambique nós estamos num outro dilema, que aqui ainda não se foi falado. Nós estamos a ser confundidos com políticos, como é que se diz isso? Como oposição, porque a oposição aqui em Moçambique não funciona. Quem está a se opor àquelas políticas do governo aqui em Moçambique é a sociedade civil. Portanto, nós temos aqui muitas das vezes vamos mesmo através, temos a grande sorte que termos o Dr. Novunga, que muitas das vezes é que carrega a bandeira e nós temos medo de até que se ficar atrás dele, nós temos medo. Portanto, ele vai sozinho para lá para poder, nos tribunais administrativos, para poder ver os conflitos que existem entre o particular e o Estado. Portanto, mesmo nos nossos estados, os nossos países, mesmo os advogados dos nossos países nunca nos fazem conhecer o que é isso de direitos. Portanto, se eu vou ter com um advogado hoje e dizer que tenho um problema de relação de consumo, que comprei um produto, por exemplo, na China, e aquele produto era contrafeito, fora do prazo, adulterado, portanto, esse advogado não vai conseguir me dizer, vai me cobrar logo, vai dizer que você tem de pagar tal para eu poder te levar. Então, nós temos problemas muito sérios aqui nos nossos países. Ontem, quando iniciou-se esta conversa, até que eu estava na Suazilândia, vimos os problemas da Suazilândia, vimos os problemas do Zimbábue, vimos os problemas de Moçambique, que são os mesmos. Acabou de dizer ali o meu colega, que é ligado ao direito, portanto, de trabalho, estávamos a conversar sobre isso, são os mesmos problemas. E também essa situação dos tribunais é uma situação política, Então, a reflexão que eu sugiro para nós fazermos mesmo é quem é que vai atar esse guiço ao pescoço do gato. Portanto, o guiço é uma história do pescoço do gato. O que acontece é que o gato leva um sino, né? O gado leva um sino. Então, é preciso pôr aquele sino no pescoço desse gato, né? Desse gado. Então, essa história reverte-se muitas das vezes para um gato e um rato, em que o gato está a comer muitos ratos, e que os ratos chegam à conclusão que, para que os ratos não morram, temos que pôr esse sino no pescoço do gato. Quando o gato estiver a chegar, ele vai tocar, tling, 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 tling. Então nós vamos ficar atentos. Então a discussão que ficou ali é que quem é que vai pôr esse sino no pescoço do gato? Essa é que foi a grande questão, e aquilo acabou, a reunião acabou ali. E cuidado dessa reunião acabar no sentido de nós não sabermos quem é que daqui de nós vai pôr esse sino no pescoço deste gato, para nós não sermos devorados. Então, eu estou a gostar muito das abordagens que está a sugerir, que está a pôr, mas isso me preocupa, porque nós saltamos várias etapas, nós fugimos daquilo que era a essência da SADC, e estamos até agora já discutimos o livre comércio livre entre a África. Já estamos a discutir isso para os povos aqui em Moçambique, Zimbábue, Malau, África do Sul, entrar num processo de livre comércio. Mas temos problemas, ainda não resolvemos os problemas da SADC de 2021 até hoje, ainda não resolvemos. Mas estamos a tentar pôr um tribunal. Como é que nós vamos pôr um tribunal se dentro das nossas casas nós não conseguimos varrer? Esta é que é a reflexão que nós devemos, portanto, aprofundar aqui. E essa oportunidade eu vejo aqui que há muita vontade de se fazer isto. E não sei se nós daqui vamos ter que sair com a agenda, dizer que vamos substituir esses políticos, porque nós estamos a favor portanto, das pessoas. Obrigado.
That was profound. So now we are left with more questions, isn't it? And I don't think we can answer all of them. So the challenges that we are facing in SADC are very political. I mentioned earlier, I think when I started, I asked, what political capital do we have as activists in order to influence policy? Because what we do is go to communities, we talk to communities, we conscientize communities, we draft papers, we publish them, and nothing happens. Next year we do the same thing, and the year after that, and the year after that, but there's no real change on the ground. The challenges in Mozambique are not unique to Mozambique. Zimbabwe has the same challenges. Swaziland has the same challenges. Zambia has the same challenges. But we deal with these problems in silos. Mozambican solution to Mozambique, Zimbabwean solution to Zimbabwe, Zambian solution to Zambia. And we've been doing that since independence. And yes, that worked. I think that's the point that the previous speaker was driving at. And how do we achieve our objectives if we are working in silos like that? I didn't quite get the analogy about the rats and the mouse, the cat and the mouse, but I believe that it's about the strength in numbers, was it? All right, so there's one speaker once said, 1,000 needles sometimes can be better than an axe. I don't know if that's true. And I'm not too sure about 1,000 rats being better than a lion, but yeah, but I think there's strength in numbers. So this issue of operating in silos, I think that's the main weaknesses. Most of the challenges that were outlined here are really not unique to Mozambique. They're there in Zimbabwe, they're there in every SADC country. But we operate as individual states, and that has not worked. Maybe it's time to reconsider strategies. All right, program director, where's the program director? Yes, ma'am, can we take 10?
Yeah, of course, no problem.
All right, okay, are we still good on time?
I believe we are, although you have your slot until 12 o'clock.
Okay, all right. We started a bit late though, but...
Okay, let's say 12:15 then, because we started about 15 minutes late.
Okay, no problem. Okay, so we can just take 10 minutes just to stretch. I can see some people are falling asleep, so just to stretch, drink some water, and come back. I'm told that human mind can only concentrate for 1 hour, 15 minutes. After that,
Reconhecendo que em Moçambique a situação dos direitos humanos continua preocupante e os defensores de direitos humanos são frequentemente sujeitos às mais variadas formas de repressão, perseguição, rapto e violência psicológica e física, a Rede Moçambicana dos Defensores de Direitos Humanos trabalha para impedir o fechamento do espaço cívico e fortalecer a capacidade e resiliência dos defensores de direitos humanos no país. Estabelecida em 2020, a Rede Moçambicana dos Defensores de Direitos Humanos fornece assistência técnica para organizações locais centradas em direitos humanos, bem como proteção para defensores de direitos humanos em risco. A proteção envolve proteção física, apoio legal e apoio médico. A Rede Moçambicana dos Defensores de Direitos Humanos também fornece segurança digital com foco estratégico na melhoria dos direitos digitais e de higiene digital dos defensores de direitos humanos em Moçambique. Além disso, e igualmente importante, a rede fornece apoio psicossocial a todos os defensores de direitos humanos como um viés estratégico sobre os grupos vulneráveis. Juntos defendemos. Juntos defendemos.